Happy New Year. Welcome to the regular board meeting of the Multnomah County Board of Commissioners. Commissioner Singleton is excused. She may be joining virtually for part of the meeting. I do want to mention that as it is the beginning of a new calendar year, we have a new vice chair, Commissioner Vince Jones-Dixon from District 4. He'll be stepping in as vice chair for the 2026 calendar year. And that's part of our resolution in Home Rule Charter. There's no action required by the board. We normally rotate among districts, and so really glad to have you in that position this year. So thank you. And I want you can give a speech. Yes. I did want to thank Commissioner Bram Edwards for serving in that role last year and for stepping in as needed for running these meetings when I wasn't able to. Audience members, I want to start by asking you to please silence your electronic devices. I would also like to remind you that in addition to the audience in this room, we have people watching and listening online, so please consider your language and comments and testimony today. Today's meeting is a hybrid board meeting. Some presenters and guests will appear in person, some will appear virtually. For those presenting virtually, please mute your mic when not speaking, and when presenting, make sure to unmute your mic and turn on your camera. For those joining us in person to provide public testimony or to present, please turn your mic on when you begin speaking so that the green light is showing, and off when you've completed your remarks so the red light is showing. And for all presenters, please state your name for the record before speaking or responding to questions. May I have a motion on the consent calendar? So moved. Second. Commissioner Bram Edwards moves. Commissioner Jones-Dixon seconds. Approval of the consent calendar. Will all those in favor please say aye? Aye. The consent calendar is approved.
Opportunity for public comment on non-agenda matters. This is the time for the board to hear public testimony, not for board deliberation. When it is your turn to speak, I'll call your name and unmute you or call you to the presenter's table. I'll set a timer for 3 minutes when you begin speaking and announce when your time is up, at which point please wrap up your sentence. Chair, we have 6 people signed up for verbal testimony, and we received 1 written testimony, which was shared with board members and staff. So I'll call 4 folks at a time. Injured and Pissed Off, Ann Casper, Robert Liberty, and Dan Hagan.
My name's Injured and Pissed Off, and I talked to the Portland City Council yesterday about this fuel truck that pulls up out in front of the new county courthouse, and I showed that, and there was press that was in the room, and they didn't mention anything about it. And my speech was a scandal, wifey white whopper, and I explained on the even here before about it. And I've talked about grievous and bodily harm, breaking my hip and 2 fractures to my spinal cord and being mistreated at the hospital, and grievous and bodily harm, medical malpractice. There isn't anything that the county and city hasn't done. I said that the reported crime, my wallet, and they were going to steal everything while I was in the hospital, and I wasn't even allowed to take my wallet or my $7,000 plus, which I got back, but that's still a criminal act, even with returning the money. There was other property that was stolen, and I don't like it at all, and I'm receiving medical treatment now. I had an MRI, and of course there's no results, but I had an eye appointment, and I have 2 cataracts, and they're gonna supposedly remove them or do something about it. And I had chronic, I was went to a very nice care facility yesterday, and it was super nice, and I met Trouble there. It was a cat, some kind of a gray, and I thought that was pretty funny. The person introducing the cat is the name Trouble. Of course, she didn't know my name, injured and pissed off. I liked Trouble yesterday. I guess I've got memory problems. My time's up. Thank you.
Thank you. Good morning.
Good morning, Chair, Commissioners, and Marina. I'm Ann Casper, a student in immersive virtual reality at University of Oregon. And as you're looking at the budget right now, know there's $1,002,000 about that you've graciously set for us mental health peers that's not being used in the way that we agree with. I'm speaking about the Behavioral Health Department of Office of Consumer Engagement. I'm simply asking to defund the entire office and to use the $1 million to fund and empower mental health advocacy and connections to you, the commissioners. We as advocates fought for the office at the political level for 10 years. Our vision was to have an office to educate peers how to advocate and create connections between you, the chair, and the commissioners, and us. Since that office has been officially open for about 7 years, that has not occurred. Nothing has occurred. The first 3 peer employees who spoke up about mental health civil rights were fired, and since then you've only hired peers who are interested in addictions. The results are that we as the people with mental health issues have no place to go, and services do not work for us, and you don't know why. And we continue to go in and out of the jails and the hospitals. The BHRC, originally supposed to be made for us mental health peers, is a place that we don't feel welcome at. Yesterday, I was at the Behavioral Health Advisory Committee observing it, the very committee you're supposed to hear from, and that many of I heard that how many of those official council members are very frustrated. That is because the Office of Consumer Engagement has only allowed them to do basically one thing in the whole year, and that is to name a facility. At the council meeting yesterday, they were told that it has to do with the Sobering and Crisis Stabilization Center, that the name they decided on is now not acceptable. Many council members are really frustrated and perhaps angry at you, Chair Vega Peterson. I'm not even sure that anyone in your office is even pushing for a name change. Here are some of the quotes from the members of the Behavioral Health Advisory Committee. It's wasting taxpayers' money to work on a name change. The money could be used to improve services. We council members are looking to do real work rather than just rename a facility. It's just window dressing and an excuse to keep us from doing real work. There are multitudes of other important topics to be addressed instead of wasting our expertise. Renaming the facility is a rootless endeavor. So it's time for change. It's time to stop wasting the $1 million. I never dreamed I'd be speaking up to ask for the destruction of an office I spent 10 years creating. I admit we advocates were wrong at that time, and your office is actually hindering communication between us, the peers in the community, and you, the commissioners and chair. So it's time for change, and I know you commissioners want the best for us. You need our guidance and how to get there. It's time for change, time for empowerment, and invest in us. Thank you.
Thank you. Good morning.
Good morning, and Happy New Year, Chair Vega Peterson and members of the County Commission. I am Robert Liberty. In March of 2015, I had the honor of being appointed by your predecessors to serve on the Columbia River Gorge National Scenic Area Commission. I was reappointed in 2019 and again for a final 4-year term in 2023. I'm here today for 2 reasons: to thank you for this opportunity to serve and to explain why I'm resigning from the commission effective immediately. And I hope you'll indulge me another minute or 2 beyond the 3 minutes. The Columbia River Gorge is a beautiful and unique combination of ecological, geological, scenic, and cultural wonders. It attracts more than 2 million visitors from around the U.S. and the world each year, which is about the same as the U.S. Capitol. The Columbia River Gorge National Scenic Area Act was passed in 1986 with bipartisan congressional support because local control had proved inadequate to protect those magnificent resources from sprawling residential, commercial, and industrial development. I have served as vice chair and chair of the commission including during the final and challenging year of the update of the National Scenic Area Management Plan in 2020 during the pandemic. I'm proud to have helped draft and support overdue improvements to the management plan that provide better protections to declining salmon species, reduce future risks of forest fires by limiting new homes in forested areas, and rationalize a process for deciding whether and where to adjust urban growth boundaries to meet needs for jobs and affordable housing in the 13 Gorge communities. In recent years, I have observed many growing threats to the Gorge. These include the gentrification of working lands with luxury home sites for the wealthy, the conversion of working agricultural land into backdrops for events, venues, and restaurants, and rapidly accelerating fires resulting from climate change. In the last year, I've noticed resistance to addressing the concerns of our tribal treaty partners, even though our chair, vice chair, and another commissioner are members of those tribes. The commission is also under increasing and unceasing attacks from development interests and ideologues who are opposed to government restrictions and perhaps any government at all. Those perspectives have their representatives on the commission today, as in the past. Last year, the Washington State House of Representatives voted to defund the National Scenic Area with wide support from Democrats. One Seattle area Democrat explained his vote by saying he thought the Gorge Commission administered the private Gorge music venue in George Washington. Although most but not all of the funding was restored, this incident illustrates two other threats to the Gorge: ignorance and complacency. Sadly, the Commission's work plan for the remaining 14 months of my term will not address these threats. If I did, I would stay on the Commission. Instead, the work plan is focused on finishing up prior lower priority tasks, routine operational matters, and addressing the agenda of the pro-development members. May I finish, Madam Chair?
How much more do you have left?
About 3 paragraphs.
Why don't you try to summarize? Okay, go ahead.
Thank you. Meanwhile, I observe the erosion of Oregon's remarkable and unique system of land planning and regulation. No other state has a system that combines stopping sprawl with increased equity in housing and transportation, rural land conservation, and prudence in the use of taxpayer funds. But it's being undermined by hostility of Governor Kotek and growing corruption in the form of pay-to-play politics, particularly evident in Washington County. As if that's not enough, the foundations of a republic are under attack from the deeply corrupt, authoritarian, oligarchic, and chaotically incompetent Trump regime and its supporters. I am 72. Those bigger challenges must now become the focus of my limited time and years. For these reasons, I'm resigning effective immediately from the National Scenic Area Commission. In picking my replacement, I hope you will give great weight to the political fact that it will be up to you to balance the anti-conservation members of the Commission with a strong and knowledgeable counter voice. Finally, I thank you very sincerely for this opportunity to serve the people of Multnomah County and the nation by helping to conserve the treasures of the Columbia River Gorge for future generations and for the sake of all the diverse forms of life with which we humans share this region and the planet.
Thank you so much for coming here today, and thank you for your service.
If I could just have the courtesy, Mr. Liberty, I know you were very involved, given that I was in D.C. at the time when the Gorge Act was passed, and I know you were very involved in the creation, and really appreciate your long service.
Thank you. Glad to hear that.
Thank you. And we have our director of the Department of Community Service in the back, and I know she'll want to speak with you after your testimony today. Margie Bradway. Thank you.
Next, we have Dan Hagan, Diane Salazar, and Lightning. Okay, looks like just Lightning.
Good morning.
Due to my important speech, I'd like to ask for another 3 minutes. My name is Lightning. I represent Lightning Super We the People X. One of the consent agenda items on your chaplains at the jail is that I noticed that you were making some statements here, almost acting like you're accountants on behalf of the chaplains. And I felt that was very inappropriate on you saying that if you can do what the IRS already has, you actually will benefit here, but we're not going to pay you any additional money for housing. So technically, you're the accountant for the chaplain right now, which I find laughable. And you know what I find really even more interesting is that from my position at Multnomah County Animal Services Hospital, you don't care about those animals. You could care less. I am proposing that we have a pet chaplain, a professional, certified pet chaplain that shows respect to our animals, we the people, that we have caged in your facility, and you then euthanize them when you run out of space, and then you disrespect them, and you don't do anything. I want to have a pet chaplain during any and all euthanasias. Period. Nonstop. If you can't fund it, let me know. I'll bring in some people that can, because I know you don't have any money due to property tax revenue plummeting. Now, issue number 2 on Maduro. President Trump, I'm going to make it very clear to you. If you want the support of the people from other countries, you have to then propose a sovereign wealth fund for the people. Tell them how much money you will make them off their 300 billion barrels of oil reserve that they have under the ground, approximate value of $17 trillion. Let them know that they should be living like the people in Dubai. Venezuela, why do you allow yourselves to live in the manner that you do and let these corrupt people push you down? Create a sovereign wealth fund, live like the people in Dubai, like you deserve. Now, another issue I have here too is one of the things that I don't approve of is, do we have private judges in the city of Portland? Does anybody even know? Are there people able to get their private judge and keep everything confidential? Because truly, if you are a private judge, we have a right to that data, and we have a right to go to your offices as the public and speak. Do we have public judges? My time is up. I respect your time frames. Thank you.
Thank you.
Checking one more time for Dan Hagan and Deanne Salazar. Okay. Chair, I'll move on to R1.
Thank you, Marina.
R1, pretrial update.
All right, good morning, everyone. So for years in Multnomah County, public safety system partners have been working to support and improve a pretrial system to promote community well-being and safety, protect the rights of victims, improve rates of pretrial court appearances, and ensure fairness and equity under the law. Today, we'll be receiving an update from the pretrial subcommittee of the local Public Safety Coordinating Council and Network and their efforts in response to the budget note this board passed in the fall. Before we start, I want to thank all of the partners that are here today and those of you who are not here today, and acknowledge the collaborative work by many justice system partners that's led to this presentation. I also want to especially thank Sarah Mullen, the director of LPSC, for her continued focus and leadership in this area. I'll turn things over to Sarah.
Thank you, Chair. Good morning, Chair. Good morning, Commissioners. For the record, my name is Sarah Mullen, and I'm the Executive Director of the Local Public Safety Coordinating Council. I am joined this morning by Senior Deputy District Attorney Jeff Lowe, Chief Criminal Judge Michael Greenlick, and Stacy Redding, the Executive Director of Multnomah Defenders, Inc. What's that? Oh, Happy New Year, Commissioner. We are here to update the board on our progress toward creating options for a new pretrial release system that we'll be providing to the board in response to the budget note by March 1st. Before we launch into the conversation, I wanted to give a little update, little context for our pretrial work. So Multnomah County was one of the first counties in Oregon to have pretrial release services, with closed street supervision launching in 1994 and DCJ's pretrial services program following closely in 1995. These programs were launched to help manage jail capacity and to keep folks in the community while their cases were being adjudicated. When those programs launched, they were innovative programs. But since then, we've really learned a lot about the field of pretrial. Pretrial advances have been made because jurisdictions have chosen to try things new to help achieve their goals. And we've learned that the most effective pretrial systems prioritize the least restrictive conditions, emphasizing support over surveillance to ensure court appearance. We know that holding somebody in custody before they're convicted of a crime should be reserved for only the most necessary circumstances. While surprising, the sheriff's decision to close Street at the end of fiscal year 26 provides us with an opportunity to reorient our county investment in pretrial away from surveillance, which we know offers limited positive outcomes to achieve our goals, and toward supportive structures that directly reduce barriers to court appearance. We understand that this is a big change, and it's a challenging time to make a change like this, given our current budget constraints and all of the other pressures that our system partners are facing. This subcommittee, the pretrial subcommittee of LPSC, came together nearly 2 years ago with a shared recognition that our system as it is currently is not working well, and that we wanted to think about how we could re-envision it to work better in the future. Everyone is committed to finding a solution. However, even with that shared commitment, there are deep philosophical differences among members of the pretrial subcommittee, and we have different ideas for how we are going to move forward to achieve our shared goals. However, even in our most challenging conversations, I remain confident that we can move towards a solution. And while we may not reach consensus on all options, I think we're going to be able to put forward options to the board that hopefully each and every agency is okay with and willing to commit to ensuring the success of, because this is going to require our continued active commitment and collaboration to both build a system of pretrial that works well, but also one that we continue to ensure its success by committing to making it successful. Next slide. This is our agenda for today. You are going to hear from me a lot in the beginning, and then I'll pass it along to our partners to really share what the impact is. They're also here to answer questions. I wanted to let you know that representatives from the Department of Community Justice and the Sheriff's Office are in the audience, so they are here and available to answer questions, even though they're not presenting. We're going to be talking about the specific points in the budget note that the subcommittee's been working on, really focused on those options. Jeff and I will be covering the pretrial process just to have a shared base of how our pretrial system works here, although we're not going to deep dive into the nitty-gritty aspects of it. And then we'll talk about the subcommittee membership and the work that we've been doing, ending with the importance of pretrial release programs and the impact that pretrial detention has on individuals in our community. Next slide. All right, so these are the subcommittee focus points. This is not the full budget note. And I wanted to make that clear because we'll talk a little bit later about work that the LPSC staff is leading to address the other points that the board requested. The subcommittee is really focused on the points about creating options that are data-driven in terms of how we are going to prioritize clients, recognizing that this is a program that we're creating in a constrained budget, and we cannot serve every person well, and we need to prioritize who these programs are for. Looking at the pros and cons of each delivery model, so who is going to actually do the service. Looking at models that enhance public safety and pretrial justice, that is a commitment that the subcommittee has made over and over again. And then also looking at what steps that we can take now to improve our system. And models, and again, models that are in line with national best practice, including but not limited to those that were outlined in the Justice System Partners Report. Next slide. All right, so this is an image that shows our pretrial process. So everyone who is booked into the Multnomah County Jail who has a new Multnomah County charge is administered the public safety assessment. That is the risk assessment tool that we use at booking. That's administered by DCJ RECOG officers. From our last presentation, you may remember that we used to use the Virginia Pretrial Risk Assessment Instrument. When we had that tool, because it required an interview, we were only able to interview and get risk information on about 40% of people coming into our jail. With the public safety assessment, because it is largely automated and doesn't require an interview, we are now able to have risk information on 100% of people with Multnomah County charges who are coming into our jail. So we have universal assessment, which is a really big step forward for us. The public safety assessment is also a nationally validated tool that is probably the most researched pretrial risk assessment tool available. After the administration of the public safety assessment, RECOG staff uses a presiding judge release order to determine who is in release group 1, which is release on recognizance, release group 2, which is conditional release, and release group 3, which is held until arraignment. The determination of those release groups is made by charge, and the initial charges are determined by the Chief Justice of the state of Oregon with local overrides that are created by our local Multnomah County presiding judge in partnership with Chief Criminal Judge and partners. And those overrides and charges are looked to determine who is in each category. I'm now going to hand it over to Jeff to talk about what happens from arraignment on.
Good morning, Jeffrey Lowe, LOWV. I'm a senior deputy at the Multnomah County District Attorney's Office. I supervise our arraignment court. I have 5 deputy district attorneys that appear each week in our arraignment courts. That is 3 separate courtrooms with a total of 24 sessions per week. In any given arraignment court, there will be between 30 and 50 cases heard within a 2 to 3 hour span. And so we spend a lot of time addressing new arraignments as well as new court hearing dates because a person has been in warrant status. The PSA, to be frank, is one that my office does not rely upon very heavily when we are making our release arguments to an arraignment judge. And that is because what we are being driven by is the Oregon statutory framework that we have under ORS 240, 135240 and 135245. And specifically, we're looking at the primary release criteria. Reasonable protection of the victim or the public, the nature or current charge the defendant is facing, defendant's prior criminal history, and if any previous release pending trial, or the defendant has appeared as required, any facts indicating the possibility of violations of law if the defendant is released without regulations, and any other facts tending to indicate the defendant is likely to appear. So my deputies are spending a lot of time digging up information to present to the court in order to make the right type of release agreement or release decision that we can hopefully get from the court. People can be set out on release on their own recognizance or some level of PRS, 1, 2, or 3. PRS level 1 means that they are reporting by phone once a month. PRS level 2 means they're reporting by phone twice a month. PRS level 3 means that they are reporting more often than that. They are reporting once per week by phone, and if they are on PRS 3+, then they are weekly reporting by phone, and potentially they are to appear once in person with a release officer or close to it at this time. One of our concerns always is not just the safety of a victim or the public with regards to the pending criminal charge, but also the likelihood that a person will return to court. There are currently more than 15,000 bench warrants outstanding in Multnomah County because of people's failure to appear. And so that information is one that we want to give to the court. The court ultimately makes the decision, hearing arguments both from the state as well as a public defender that is currently in the courtroom as well, whether or not a person is appointed counsel. I will tell you that the issues that we are seeing in arraignment court over the last several years is also driven by the lack of counsel being appointed in many cases. It's causing a lot of churning, and so this has been an additional stressor upon the pretrial system here in Multnomah County, with so many people having cases that are unresolved because we simply can't constitutionally move forward until counsel is appointed. If the court makes a determination that they cannot be out on conditional release because of their concern for the victim safety, public safety, or the failure to appear rate, then the court next option is to set security. and that person at that point can raise 10% and perhaps get out of custody with other conditions upon them. There are many people that are currently facing that particular situation because we simply are not confident that they will return to court or that pretrial release is insufficient to make certain that public safety and the victim's safety is ensured. There are some cases, a handful of cases, where release is denied completely. The first is in murder cases. That is an entire court hearing in and of itself called a murder release hearing. And if the court determines that the evidence is, that the proof is evident or the presumption is strong that the person is guilty, then the court must hold them in custody. We also have, under ORS 135240, the ability to have preventative detention, but it only applies to violent felonies. And there is a two-phase process by which to determine whether or not that statute applies, which does require evidence being taken by a court and a judge making a determination about whether or not preventative detention will be applied. If it does, then that person will be held until the conclusion of their criminal case. Are there questions for me right now about arraignment?
Yeah, I understand the use of prior behavior and victim risk. What is the line, or how do we balance that in this country we presume innocence in front of a court, and yet we're, if I may, I may have misunderstood, but it sounds as if you were saying we're actually looking at a circumstance. Oh, I totally believe you might too.
Thanks for all the detail, Jeff.
Teamwork, yeah. Well, I gave up.
Okay, all right, so sorry. Oh, thanks. Okay, I apologize. Yeah, I'm just trying to understand from what we are doing and also where we might go, that balance related to the presumption of innocence, and yet using, I don't know if you haven't even gone to a grand jury, so I assume it is just reports as evidence. I don't know if can I call it evidence? I don't know what the right term is when it's not in court record yet, as a reason to, as a factor in holding someone. I don't know, I'm not an attorney. What is that today, and what is best practice, or what have the conversations been?
Sure, thank you. I'm going to defer to Chief Criminal Judge Greenlick to answer that question.
Yes, Commissioner Moyer and other commissioners, good morning. I would like to answer that question because I think it's a really important one, and we've had discussions about that in our subcommittee. And again, I'm Judge Michael Greenlick. So presumption of innocence is the keystone to our criminal justice system, and it's a very important part of our system of liberty and our democracy, quite frankly. But it relates primarily to the issue of, like, are we going to convict somebody of a crime without proof beyond a reasonable doubt? So it deals with conviction of crimes and whether you can then sentence somebody after conviction of crime. So someone cannot be adjudged guilty unless it's proven beyond a reasonable doubt. That's what trial juries deal with, and that's the main function of presumption of innocence. But judges consider facts and evidence all the time in making release decisions, and they're allowed to do that. The first piece of evidence we have to consider is what's called a probable cause affidavit, because probable cause has to be established and approved by the court before the person can be held more than 72 or 96 hours. So I actually we go in on Saturdays because arraignment won't be until the following Monday, and review affidavits from police officers, sometimes from prosecutors, that establish the facts of the offense. And based on those affidavits, that's evidence. If we find that there's probable cause that the crime has been committed, we can approve of the person being held. At release hearings, we can consider all sorts of evidence. We are required to consider statements from the victim. We're required to consider, sometimes we always have these probable cause affidavits. We have other evidence. We have information about the person's failure to appear history. We have information about the nature of the offense. We have information from the defense and the defendant, and we have information from the prosecutors. And we consider all of those things in making a release decision, and which is primarily driven by reasonable protection of the victim and the public and the defendant's likelihood of appearing in court. So that is constitutionally approved, and we don't assume somebody is innocent in making a release decision. We don't assume anything about that. We consider the facts of that have been presented to us, which might include information about facts about the allegations that led to the charge.
If you don't mind, I'd like to hear Stacy's perspective on that, if you're willing to. And maybe you're in agreement.
Yes, I guess I will say.
Stacy, would you hit your mic? And then
Sorry.
don't forget to state your name for the record.
Thank you. Good morning. I'm Stacy Redding. I use she, her pronouns. I've been a public defender in Multnomah County for the last 18 years, and I became the executive director of Multnomah Defenders 2.5 years ago. I would agree with everything that Judge Greenlick just said. I would flag, however, that I believe we have high dismissal rates. We do see a number of our clients who are held pre-trial, and then their cases are dismissed on the eve of trial or morning of trial, with the state being unable to proceed. We also have clients who are acquitted. Yes, so I do see people who are, in effect, punished for allegations that they're never convicted of because they are detained pre-trial or held to conditions pre-trial. Thank you.
Any other questions here? Oh, yeah, so I think we should wait till the end unless it's like it's like a clarifying question, just because we have so much material and I know we have a lot of folks to hear from. Thank you.
All right, thanks, Chair. Next slide. All right, so I wanted to highlight the pretrial subcommittee membership, and this is largely because I wanted to acknowledge that all of these folks have been participating in additional meetings, longer meetings, taking a full day to have a pretrial retreat, to really come together to think about how to create a solution that we can all get behind. And I wanted to thank everybody who has really taken the time to do that, recognizing that all of these systems are facing a lot of pressure right now, and it takes a lot to take time out of that everyday work to come and participate in this. We have folks represented from our county departments, specifically our Department of Community Justice and our Sheriff's Office. We have representation from our Domestic and Sexual Violence Coordination Office. We have representation from the Chair's Office, from District 3, from District 2. We have additional representation from the courts with judges and trial court administration, recognizing that the court really plays an outsized role in this pretrial release process, and we want to make sure that they are well represented. We have law enforcement who's participated. We have public defense. We have the DA's office, who I somehow didn't put up there. Sorry, we know you're here. And we also, I'm like sitting right next to Jeff. And then we also have other partners. We have a Justice Fellow, we have the Criminal Justice and Policy Research Institute, and then we have Justice System Partners, who's been our technical assistance provider through the MacArthur Foundation. So I just want to acknowledge all of these legal system partners who have played a big role in this work to date. Next slide. And this is where we are now. So we launched the subcommittee in May 2024, and this is certainly an oversimplification because we have had many, many meetings in between. There just was not enough room on the slide. At the same time we launched, we started the process of having these justice system partners reports commissioned. And so those were happening at the same time as we were meeting. In October 2025, after our trip to Tucson, we received the budget note that was approved by the Board of County Commissioners, and that accelerated our work. And we began meeting more frequently and longer. We had a pretrial retreat in December 2025 that was 6 hours of folks' time coming together to really think about the future system and solutions. And we are here. We're here giving our first update to the board on that work. After this, we'll be sharing this information with LIPSIC at the end of February, and then we'll be creating the report for the board on March 1st. Next slide. All right, so a key part of the budget note was really thinking about opportunities in our current system. This is going to be important also as we think about the Close Street program closing and how we can mitigate the impact of that. So the first piece is really thinking about the access to technology and communication that we actually already have. So really leveraging the court's existing notification system. And while he's not here, I do want to acknowledge Neil Japort, who's the Deputy Trial Court Administrator, because he has been working really hard to ensure that we have phone numbers for everyone who is leaving custody. And that is important because we need those phone numbers to be able to get folks into the court's notification system, and we don't always have them. So I wanted to just acknowledge the work that he has been doing to push that forward. He has also been working to investigate the state's e-supervision case management program, which is a program that we might be able to use here depending on the pathway forward. So that is an opportunity we may have to enhance our court notifications and also our collection of data and use of a case management system. I also want to say that we have a lot of support and collaboration happening around this. We have MCSO who is looking to pilot some way that their corrections counselors can implement some warm handoffs to have folks better appear at their intakes, which we were seeing a lot of folks missing. We had a collaborative group that Jeff is going to talk about in just a minute, who is actively working to establish policies to decrease the population on monitoring, specifically on Close Street, and really look at a step-down process for folks who are in compliance. I wanted to also acknowledge that DCJ has been an incredibly committed partner to this process, because when folks are getting off of Close Street, often they are moving to DCJ's PSP program. And so I want to acknowledge that DCJ has been willing to accept those cases and that they have been showing up in a really helpful way. And then I wanted to say we also have an opportunity to provide more education. There are a lot of opportunities around for education. We had some judges, trial court administration staff, LIPSIC staff who attended the NAPSA conference, which is the National Association of Pretrial Services Agencies, to really enhance our learnings around what works well in pretrial. And there's ways that we can do that to think about how we use electronic monitoring and how we can strengthen the linkage between our PSA risk assessment scores and judicial use. Next slide.
So a small group of us met in order to address the issues of Close Street closing and what to do about those people that are currently being supervised by them, rather than waiting until the last minute in May 31st or maybe June 30th. That group included Judge Greenlick, Judge Celia Howes, Sarah Mullen, Grant Hartley, who is the director of the Metropolitan Public Defender's Office, which is our largest public defender's office here in Multnomah County, and myself. We met and discussed what can we do with regards to those people. So as you can see from bullet point number 1, we made a decision that the court would approve transferring all non-person misdemeanors to PSP immediately, meaning they would be on the lowest level. Non-person misdemeanors include things like disorderly conduct, misdemeanor theft charges, misdemeanor criminal mischief cases, misdemeanor DUI, a number of other cases along those lines. Those are the non-person ones. This did not include misdemeanor assault, misdemeanor strangulation, or menacing. And so that was one first thing that we addressed. The next is that we agreed that an automatic step down could occur for people that were on PRS-2 or PRS-3 if they had 90 days of compliant appearances. And so those people will be stepped down automatically, meaning no court hearing, down to PRS level 1, which means they will only need to report once a month by phone. What we didn't agree about was an automatic step down to release on their own recognizance. There have been enough anecdotal issues over the years by my office with regards to people that are on a low-level crime, yet something happens where we need to move swiftly in order to seek a warrant for their arrest for public safety or for a victim's particular safety. We cannot go directly to a judge in order to get that warrant when someone is represented by counsel. However, a pretrial release officer has the ability to create an affidavit and submit that to the court. And so on that particular point, we declined to agree at that point to automatic ROR. That does not preclude, though, the opportunity that every defendant has at every court hearing to have their level of release readdressed by the court. So a person appearing in court can ask to go back to ROR, and that does happen on a very regular basis. As the lawyer that appears mostly in Justice Center Courtroom 1 for some of our misdemeanor arraignments on a regular basis, we have discussions about removing all PRS requirements and putting them on ROR, which seems to make sense on low-level misdemeanors when they're showing up for court. Next slide.
Thanks, Jeff. So I wanted to highlight that the group also, prior to our retreat, had an equity lens training. And this training was conducted by our then interim Chief Diversity and Equity Officer, Teresa Kelly, and also the Multnomah County District Attorney's Office Equity Manager, Maddie Giraldi. And so I wanted to highlight these questions where we really looked at the 5 Ps and talked about how they would apply to our equitable transformation of our pretrial system. Talking about what client need and outcomes are at stake, who benefits, who's burdened, and how does history shape their experience? What parts of our system feel disempowering and how can we increase support? What disparities in data do we need to look at? And whose voices are missing and how do we measure equitable success? These are just a few of the questions that were asked and we thought about in the presentation, really to refocus our efforts from where we generally are around system impact and jail capacity and burden on our courts and things like that, to really thinking about the individual person who is impacted by these systems every day and what their experience might be going through them. We reflected on where in our current pretrial process might people unintentionally experience trauma or inequity. And I think we acknowledge that at each point in the process, there was an opportunity for somebody to experience that trauma or inequity, recognizing that this is a stressful and incredibly confusing time for someone, and particularly impacted by if somebody doesn't understand the materials in front of them for whatever reason, if they don't understand what's happening in the court process. The arraignments move really quickly and it's really hard to follow. And being held in custody prior to that arraignment hearing can be really traumatizing, particularly if you don't have the opportunity to meet with a defense attorney and really understand what's going to happen at that hearing. So we talked about all of those things and it gave us, I think, some background to go into the retreat with that equity lens in mind. We are certainly not experts in the application after a 1-hour workshop, but it gave us the tools to start practicing equity in our conversations together and to really think about this as we try to center this work on those who are most impacted by the pretrial process, those going through it, those who have potentially been harmed as part of this, and those who are living and working in our jails. Next slide. All right, I wanted to highlight a few things from the pretrial, from the JSP report. And this is the report that really did a national survey of what is working well in pretrial. There is no perfect program. If there was, we would certainly be presenting that here. However, some jurisdictions have started to try new things to see how they could better increase success in getting court appearances and better ensuring community safety through investments in supportive services and individuals. And so the JSP report looked at different systems. They examined the data that those programs had to offer, and they did interviews. And this is what came out as things that actually worked to improve those pretrial goals. So shifting from a compliance-focused monitoring program to a supportive pretrial services model, establishing separate support-focused programs separate from the legal system. So not that they're not communicating with the legal system, but that they're not run by the legal system. implementing warm handoffs to ensure that somebody is getting from point A to point B, and then establishing targeted support services based on a needs assessment that address folks' basic needs, transportation, accessibility, housing, and substance use. And these are just a few examples that we've seen across the country. We know that here in Multnomah County, we are not the same as Chicago, Illinois. We are not the same as Tucson, Arizona, right? But we can learn lessons from those jurisdictions about what worked well, and we can try them here. Next slide. All right, so that brought us into our pretrial retreat. This was a day-long retreat where everyone came together with the objectives of establishing a point of view on our guiding principles to inform our redesign, recommending key components of a redesigned pretrial system, and then thinking about who could actually deliver the key components that we were interested in seeing. We were fortunate enough to have Justice System Partners fund facilitation for this retreat. We also were able to bring Kate Vesley, who is the Director of Justice Services in Pima, Arizona, up to help support this retreat and also do some work with our judges on Friday before the retreat. Next slide. All right, so this is the agreement of aspirational principles that we wanted to see guide our work. And this came out of an exercise with all of us sort of talking and working together. We came up with these 5 principles. The first is due process, the presumption of innocence, using the least restrictive conditions, considering alternatives, and honoring the rule of law. Procedural justice, which delivers equality and fairness. Prioritizing victim and public safety. Using transparent, data-informed decision-making and accountability. And then defendant support and success. These are the principles that we need to keep returning to as we continue to have conversations about what a future pretrial system could look like. Next slide. And these are the retreat concepts we came out of. We started the day by acknowledging that there is not a dedicated stream of funding to fund this new work. We don't have a pot of money that we are working from, and we are all in budget constraint. We started from zero with a menu of options that were both based in well-known kind of practices that work from the report and from other places, as well as practices that we currently do. And an option to say, if we start from zero, what do we want to see in a redesigned system? And this is what came out of it. These ideas represent conversations and not consensus. So I just want to make that very clear that we are in the midst of this conversation right now. And so this is not representative of what the option is going to be. This is the start of the conversation. So looking at voluntary transition services is something that most folks agree upon. And it's really thinking about things like peer navigators, looking at cell phones, because court notifications only work when somebody has a phone, and many folks that we are working with don't have access to phones. Referrals in connection to existing county services. This is not about creating a whole new group of services for this population, but really leveraging the existing services where folks might already be connected or be able to be connected. Having something that's located within or within walking distance to the jail, I think, is incredibly important. It is hard to get from point A to point B, especially if it requires a bus ride or a long walk. So having something that's really easily accessible, and then being able to have that warm handoff or pre-release connection to make sure that people know about it before they're coming out of custody. The second component is having some level of pretrial monitoring. This would be non-voluntary. It would be limited to specific case types or risk levels, which we have not yet determined. It would require potentially in-person compliance monitoring and reporting to the court with a real focus on barrier reduction to improve successful court appearance. So focusing not just on those phone check-ins, but really on, do folks have transportation? Do you have childcare for when you need to be at court? Do you need to get a ride to court? Do you need to, what do you need in order to be successful in appearing to court? Time limited potentially. We've seen these time limited programs work elsewhere, where from the start of the program, everyone acknowledges that this is time limited with compliance, with showing up at court, right? With not committing new offenses while on pretrial release. When I say non-enforcement focused, I mean that it's not housed within a law enforcement agency. Pretrial is not an arm of law enforcement, right? Again, these are folks who have not yet been convicted of a crime. And so thinking about another place outside of the law enforcement, legal system where this could potentially be focused. We have not determined that. We're still talking about it. And then referrals made to transition services and existing county resources. Next slide. All right, another concept is folks are still interested in seeing some level of electronic monitoring in SCRAM, which is alcohol monitoring, but agree that it should be limited to cases with victim safety concerns and with geographic restrictions. The group acknowledged that electronic monitoring in SCRAM are expensive, and they are generally not effective at improving court appearance. These are conditions that the judges impose when there's a community safety concern. However, we have seen EM used fairly extensively, and that's not just here, that's everywhere, right? Folks are using electronic monitoring, but we have limited evidence to support its success. What electronic monitoring can do, and I think we just want to be really realistic about this, is it can document violations of after the fact and increase feelings of safety among victims, right? It creates a paper trail, but it doesn't create an opportunity where somebody's electronic monitor goes off and have an immediate response. That's not how the electronic monitoring works, right? Most of our electronic monitoring here in the county is passively monitored. Next slide. Okay, another pretrial retreat concept, and this is widely agreed upon, which is court reminders. And court reminders are one of the most well-researched ways to get people to come back to court, and they're very cost-effective. We currently have phone and text reminders in Multnomah County that come through our statewide Odyssey system. We have had them for about 20 years, and we use them. They're sent at 7 days and 1 day prior to the scheduled appearance. Unfortunately, we have the limited ability, because it's a statewide system, to modify the content of those messages. So if we're talking sort of well-known practices, they generally are based in behavioral messaging. So things like, do you have, hey, you have a court date on this date, do you have transportation to get back to court? Do you know where the court building is? Things like that. We also have, it would be an addition essentially to adopt new software. We sort of agree among our group so far that using the existing service and just having better use of it would probably be the best path forward. However, we can provide information on other software that's available to include that behavioral messaging and potentially more frequent messaging. There's some research out there that suggests that 7 days, 3 days, and 24 hours are the best intervals. Next slide. All right, and then we discussed the delivery mechanism. So really thinking about, from the core components, who could actually deliver the services that we want? And we looked at the court, we looked at county departments, and we looked at a community-based provider to see who could actually do what we as a group kind of put together. And this is really where we're going to continue to have a lot of discussion. I can't say we agreed upon one or the other because we haven't come to that consensus yet or conclusion. Next slide. All right, and so our next steps are really to dive into those delivery mechanisms and then spend time drafting the options for the board and to discuss how do we transition away from our current model and what does that look like. This is a tight timeline, and so we'll be working all through January, continuing to meet to try to come to some options that we can agree upon together, and then I believe we'll probably be spending the majority of February drafting the report so that we ensure everybody is comfortable with what goes to the board. Next slide. All right, and then I just wanted to highlight other ongoing work. This is a huge effort that impacts a number of other county departments and has a lot of need for collaboration. So other work that has been happening in addition to the subcommittee meeting is that we have our PSA validation that was presented to us about 2 weeks ago. We'll be receiving that report in about 2 to 3 weeks. We are also working on a cost analysis in partnership with the Central Budget Office and budget teams at DCJ and MCSO, as well as our partners at Justice System Partners. LIPSIC staff, myself, and Lili Yamamoto have been engaging with our Human Resources Department as well as our County Attorney's Office to talk about labor and liability concerns. We'll be meeting with the Domestic and Sexual Violence Coordination Office in January to talk about what victim survivor supports look like in the pretrial stage. We are also doing a review, we're coordinating a review of cases so that we can explore overlaps between existing county services. We have the Housing Services Department who's already committed to helping us with this project, looking at folks who have been assessed at the highest level, at the 3+ level, and seeing where they've been connected in housing services. I'll be meeting with the Department of County Human Services at the end of the month to talk about if we could do something similar. There are a lot of data governance concerns, but we'll be working to see if we can get that information prior to the report. We will also be working on a data snapshot. DCJ and MCSO are working on that right now with specific data points so the board understands exactly who is on monitoring, what their charges are, what level they're on, and demographic information as well. That should be completed by the end of this month. And then we are hosting sort of monthly transition planning meetings with the Sheriff's Office, with the Department of Community Justice, with the COO's office, and we'll be also including the Central Budget Office in those meetings moving forward. So there is a lot of work happening behind the scenes for this as well, so that we can provide information to the board that is complete and thorough, so that you all can make the challenging budget decision that you have to make. Next slide. All right, I am now going to stop talking and pass it along to Chief Criminal Judge Michael Greenlick to talk about the importance of pretrial release programs.
Good morning. And then just hit the button. There you go.
Okay.
Thank you, Judge.
Thank you, Judge Michael Greenlick again. I just wanted to start by maybe providing just a little bit of historical context. I started as a public defender 40 years ago, and at that time, most people were released on pretrial release. I believe we might have been one of the first jurisdictions that didn't rely primarily on cash bail. We didn't have Senate Bill 48, so they weren't being released before appearance in court, but it was most of my clients, the whole time I was a public defender, were out of custody. And so there's always been an emphasis on this. What's changed over the years is that I think the acuity and the seriousness of the offenses and statutory sentencing mandatory minimums and those types of things have kicked in. And so it has become more of a challenge. Back when I was first starting, people used cocaine as the drug. Now it's methadone and heroin and methamphetamine. And so there are many more challenges to defendants, many more people are houseless, many more people suffer from mental illness. There are significant challenges. So that is sort of the context. The year before I became chief criminal judge, I spent a lot of time in our arraignment court, seeing people appear before me who were going to be released, who had such high acuity, who could barely stand up because of their withdrawals from fentanyl addiction, fentanyl use. And it was just heartbreaking because they were basically pleading for help and there was nowhere to direct them. And you also knew that there was a strong probability they weren't going to make it back to court. And so when I became chief criminal judge, the first thing I did is have a conversation with Commissioner Myron about enhancing our medically assisted treatment for opioid use disorder in the jails beyond Suboxone, which I think probably hasn't been highly effective, talking about methadone and other methods of delivery, and she spent a lot of time on that issue. And when I became chief criminal judge and we started this pretrial release program, I found out about the Clackamas County Transition Center, and I brought that to our group. And that ended up in our conversation in Pima and understanding about transition centers and transition services to help people transition into the community. The reason I make these points is because when you're a judge appearing in that arraignment court, I want the commissioners to just remember that most of the people that are being held where we're making release decisions are the more serious situations. They're people who have either failed to appear for court multiple times. Sometimes you see folks who have failed to appear 6, 7, 8 times on the particular charge, and sometimes 40 or 50 or 60 times in their lifetime of being involved in crime in our community. And so that is not an unusual thing. You have people who chronically don't come back to court, and then you also have people who have committed offenses that even if they're not violent offenses, violent serious felonies that will be held for obvious other reasons, they're folks that are, really impacting the community in a significant way, stealing cars, eluding by driving in a dangerous way, having guns on them, having lots of drugs on them. And so these can be really difficult situations, especially since most of these folks also have pretty significant criminal histories. And we are supposed to primarily consider factors like reasonable protection to the victim and the community and failure to appear history. And we are supposed to be considering releasing people on the least onerous conditions, but it's not just least onerous conditions. There's a remainder of that statutory clause. It's least onerous conditions reasonably likely to ensure the safety of the public and the victim. So it's not just give you hardly anything to do. It's the conditions that we judge to be reasonably likely to assure the community and victim safety. So we need options. You know, we need options. Our judges don't go into those release hearings thinking, oh, let's think of all the reasons for holding somebody in custody. We're trying to think about reasons to release people from custody because we realize that in many, many instances, that's much better for somebody. But if we believe that somebody's there's a strong probability because of past behavior that there's going to be problems in the community and failure to appear, you know, folks are much less likely to release folks unless there's some sort of option that we have, like pretrial monitoring, that could perhaps be enhanced monitoring in some situations that would give the judge some better assurance that, that the person would come back to court and be safe in the community. And so that's why we're working so hard on this. Closed street supervision was, in my view, sort of a gold standard program at one point before they sort of got buried in cases after the adoption of the PSA. And at the time, they would oftentimes do things that probably aren't possible now. They would go do home visits and talk to family members and meet multiple times with the defendant in jail and form a relationship with the person. And of course, during those times, they were mostly used for the most serious offenses, but it was a really useful tool in giving the court some assurance that, that things would work out in the community, and they were very successful. And I understand we're not going to have the resources for that sort of program, but if a court in these serious cases, if a judge in these serious cases feels like there are not sufficient options to make a judge feel comfortable about releasing somebody, especially on that very first day, because you have to remember at that arraignment court, we hardly have any information. And whatever information we have from the defendant side, none of it's been corroborated. It's just the defendant telling their lawyer in court and the lawyer telling us. So when they say things like, oh, I can go into treatment, you know, a lot of times that just turns out not to be true. And so we don't have a lot of corroboration for anything. We're having to make these really difficult decisions. And, you know, I fear that if we don't have a monitoring program that has the capacity to provide significant support to people, there will be more people on these serious cases held in custody. So I think that's all I really needed to say today, and we'll pass it on to the next slide.
Thanks, Judge. Do you mind just hitting your mic button, and then we'll pass it along to Stacy.
Right, and again, Stacy Redding, she, her pronouns, Executive Director of Multnomah Defenders. I can add, in addition to having been a public defender in Multnomah County the last 18 years, my office staffs misdemeanor arraignments 3 days a week in the Justice Center, and beginning about a year ago, we began staffing a hybrid felony and misdemeanors arraignment docket that was newly created by the courts 1 year ago. I think Judge Greenlick told compelling stories about the members of our community who have the most acute need. I do think that it would be it's important that we all strive to make our decisions based on data whenever we do have data available. We know from the Justice System Partners report from September 2025, that report characterized the majority of bookings in Multnomah County as being single bookings. Single booking was defined as a person who had not been booked into the jail for the previous 3 years. that report, so that 57.2% of the bookings we see are folks who haven't been in our jail for 3 years. So I agree with Judge Greenlick that the folks, the stories that Judge Greenlick told, they definitely loom the largest for those of us who are in the arraignment courtrooms. That those are the most memorable stories that we observe. But it's not the majority of the people who we see booked into the Multnomah County Jail. Being booked into the jail can be extraordinarily disruptive for many folks. If a person has employment and then they're in the jail, they're at risk of losing that employment. They're also at risk of losing income just for the hours missed on income, and we do see a lot of folks who are living on the margins and paycheck to paycheck. So 1, 2, or 3 days of employment missed, if a person's lucky enough to keep that job, can be very disruptive to them financially. It also interferes with the ability to gain employment for folks who have interviews or contacts scheduled. We also have more difficulty. So my office employs a social worker and 2 case managers, and our social worker, Rebecca Menda, is here with me and helped me prepare some of my remarks this morning. And she is that expert on programming locally and connecting our clients with programs that help them find stability, which helps us improve community safety. When the people who have been booked are stable, have access to whatever services they need, that is many times the best path toward community safety. And we have fewer community resources and community placements that we can refer our clients to when they're in custody versus out of custody. There are intakes that sometimes have to be done face-to-face, and not all providers in the community have the access to get into the jail to do those intakes. Our clients also face loss of their personal property when they are booked into the jail. For example, sometimes our client's property goes to the Portland Police Bureau. The Portland Police Bureau destroys that property after 60 days, regardless of whether our client is still held in the jail with their case pending or not. And that can be devastating to folks who are already just struggling to find stability and safety and security in our community. We know, so Professor Chris Campbell from Portland State University has conducted research, and he co-authored a report in April 2022. And we know from his research that people who are detained in custody are far more likely to receive a prison sentence than those who are not. That is controlling for case seriousness. I think a lot of people hear that data and think, well, of course, the data will skew that way because a person with a murder case is very unlikely to be released pretrial. They're very likely to get a lengthy prison sentence. But Professor Campbell will tell you that is controlling for case seriousness, just making the only variable in custody or out of custody. For a person detained fully through the disposition of their case is 4.1 times more likely to receive a prison sentence over a probation sentence. For the acute folks who Judge Greenlick was describing who need drug treatment or who need mental health treatment or who need both of those sources, I think we all know that our jail is not designed to be a therapeutic environment. It's incarceration. It's not a hospital or a residential treatment facility. We know that we actually had 5 people who died in the custody of the Multnomah County Sheriff's Office last year. And finally, I'd like to highlight that defense attorneys and the providers we work with have ongoing access issues for people who are detained in the jail pre-trial. Our Sheriff's Office has been working on it, and we have Chief Deputy Stephen Reardon here observing, and he's been wonderfully communicative to me and Grant Hartley about those ongoing efforts, but we still have difficulties and problems. Our Inverness jail staffing is not returned to pre-pandemic hours where attorneys and agents of attorneys can visit their clients 5 days a week. We only have full access on Wednesdays. Our other 4 days of the business week, we only have morning access, and that conflicts with court schedules. And we also have difficulties accessing our clients on the phone, particularly at the Multnomah County Detention Center downtown recently. So I think there's disagreement in this group, but there's also agreement, and I think we all agree that connecting the folks who do get booked into the jail to services that they need, that's a shared value that I think we all have and that I'm looking forward to moving forward with. Thank you.
Thank you.
That concludes our presentation. It was a lot of information. And I just wanted to thank my co-presenters. This first board meeting of the year is a challenging one as we had to prepare our presentation during the holidays. So I just wanted to thank everybody for getting information to me and for being here today and making the time for this, in addition to everything else that we are asking them to do as a part of this process. So thank you all. And we are here for questions. I just want to remind you, DCJ and MCSO are also here if you have questions for them.
Thank you so much, and I really appreciate, again, everyone being here for this and all the work that has gone into this process. I know it's been going on for quite some time, and you know, the board's budget note is helping to bring some of this forward now. So I'll remind the board that, so this is the first report out. The second will be in March, as was shared with the final report with recommendations. So I know a lot of good work will be happening there. We are, I'm gonna keep I know that there's a lot of questions. There's going to be more opportunity to meet with Sarah or any of the other public safety and justice system partners on this, because we do have a full board meeting. So I'm going to try to balance a little bit of the time for questions among the board members. But again, like, I know everybody's willing to meet with folks. Otherwise, we do have like several more board items today. So with that, I will open it up for questions for the board, and we'll start with Commissioner Moyer.
Thank you. I appreciate that there was some grounding in bias training. I had the opportunity, because it was shared with us, to read those reports by the CJC, which I found helpful, and does bring up some like unintended consequences of pretrial detention related to equitable application of justice. I was particularly interested in the fact that for every day spent in pretrial detention, it increased the prison sentence by 0.7%. That was actually a little bit shocking to me. That actually made me my mind want to ask a bunch of like follow-up questions that are not necessarily this conversation, but because there is, and I'm not knowledgeable enough to know necessarily a fairness question related to not just who gets or does not get pretrial detention, which is very hard, and I don't think there's any system that would ever be perfect, but also it has implications in our actual criminal justice process and what type of plea deal, likelihood of agreeing to a plea deal, and sentence. It raises additional questions about how bias has to be really seriously considered. One of the questions I had was, I did not hear any conversation about bias against disability, which is a protected class, and I'm a little concerned because mental illness is an ADA-covered disability. It certainly can impair somebody's ability to show up for court, for sure. but it is not also, it is possible that that is a symptom of a disability and not a willful action. That is not universal. That is individual, but it certainly can be a factor. You know, I have seen our jail, particularly Downtown Justice Center, where we are keeping some of our most acutely mentally ill individuals. I have gone to most every psychiatric facility in the state of Oregon due to past advocacy. And I would say it is the most singly inappropriate place I have ever been for somebody with a severe mental illness. It is appalling. That is not about staff. I think the sheriff and the staff are actively trying to figure out how to take a totally inappropriate environment and make it less harmful, but it is harmful. I don't think any behavioral health expert would look at what is happening in our downtown justice system and think that that was not a cruel and unusual punishment for people with mental illness. And so I get concerned about the interplay of disability, the rights of people with disabilities, how that impacts a very real court issue of appearance, but also the very significant harm detention in such a environment is. And so as we embark on this new conversation, and I am painfully aware the court has so few positive tools to help people in this environment. I've had lots of conversations with Judge Waller. It is a community crisis that we do not have better options when we know there is an underlying health and disability issue. But where is that in this conversation? What are we talking about when we may do a disproportionate amount of harm to the individual, even though due to disability they have a significantly increased risk of not being able to navigate their court date?
I agree. That's a terrible problem we have in our community. This is Judge Greenlick. You know, sometimes I have the feeling folks are so disabled that you could take them to a block away from the courthouse, point them in the direction, and they wouldn't make it to court, and it wouldn't have anything to do with their, you know, intent to avoid justice or anything. Unfortunately, many of the folks who have severe mental illness have committed many very, very serious offenses if they're in custody. If it's a minor offense, typically what happens is they get released over and over and over again, and we keep trying over and over again to get them to court and just deal with that, with the case sometimes not getting resolved for years. But, you know, folks stab people when they're psychotic. They light houses on fire when they're psychotic. They, you know, harm people in significant ways. And in those situations, either the offense is so violent that they're preventatively detained, or they're just a significant public safety risk in the community. Sometimes then it gets exacerbated because they can't aid and assist in their defense, and then Judge Waller is trying to get them to the state hospital to regain competency, and it is a significant problem driven by a lack of resources. I agree.
I don't disagree with you, Jeff Lowe speaking. I've been a prosecutor for 26 years, and it has only gotten incrementally worse each and every year since I've been a prosecutor. Fort Delta, which is where the most severely mentally unstable currently reside in our jail, is directly above my office. I hear them yell, I hear them bang, and it's awful. And that is one of the crises that this community in Multnomah County is experiencing and has been experiencing for so long. And I don't have a good answer with the tools that we currently have. I just don't. And I'm sorry that I can't give you a better answer. The best I can say is we look as prosecutors in making our recommendations at each case individually. And of course, that ultimately looks like that we are just holding everyone we possibly can. But I hope this commission understands that we're trying to do our job both for the defendant and for the public in general, and for the victim specific in each case.
This is more of a follow-up because I know we're still deep in the work. I think this is an example of multiple government entities trying to balance our competing, no, they're not competing, corresponding needs in a very difficult budget environment, which is difficult, I think, we're on all sides. I don't think there's anybody here who is not going to need to make really difficult decisions. I know the courts have to answer to whatever the legislature appropriates. We have our funding streams that have been impacted, and we have to implement that. So, in that environment where it is incredibly difficult to make prioritized decisions, and the ability to create the perfect system is not today. It doesn't mean never, but today we're in a difficult situation. What is the balance of the county is being asked to fund this? We also obviously fund jail and the courthouse. We certainly have an interest in trying to maintain an optimal jail occupancy for staff and individuals there. The court, we also share with the DA's office an interest in people showing up to court. The court obviously also cares deeply about public safety and individual liberty. How are we, in that framework, and knowing that we will make cuts, not necessarily here, but in general, cuts are happening. There will be DCJ cuts. There will be cuts in the sheriff's office. How are we balancing these needs? And I don't expect that that's a clear answer, but it is, I think we all are hoping, my hope is that we land in a mutually beneficial as just place as we can. And this is a very helpful presentation, but I didn't quite get where we're headed, which is fine. You have to March. Good luck. But just that's kind of my leave behind. It's as a commissioner who has to vote on budgets, and this is not going to be a fun budget year, my hope is that what comes forward, and there may be levels of disagreement within it, but in general, a package that acknowledges the financial realities we're all in and tries to balance those needs, knowing that there's a need for the DA's office to be able to proceed. There's a need for the court to be able to function and answer to the public. There's a need for our jails to stay at a safe population. And, I think we all would like to not see the need for matrix release whenever possible. So I leave it there. My dream that in March you have come up with this incredibly affordable, amazing process that delivers all of that, but is, if not, a very balanced approach. And I appreciate this really difficult work. So thank you.
Thank you, Commissioner Broome Edwards.
Thanks for the presentation. And I join Commissioner Moyer in her dream. So we'll see. I'm, as someone who co-sponsored with Commissioner Moyer the budget note, I want to thank the four individuals here today, but also all the people who have been involved in the discussions over the last several months. I think when the sheriff indicated that Closed Street was not a program that she was going to continue to operate, or that it prompted us to, I think, a much probably needed relook, an examination of the current pretrial system. And so I appreciate the work that's gone in to date. And while there's differing perspectives, I think that's really important and actually will help build a much stronger pretrial system, to have those different perspectives at the table. And just listening to both the Department of Community Justice and the Sheriff's Office, we may have had a pretrial system in close street supervision, but it may have been a little bit in name only, just in terms of what people thought that meant and actually what was happening. So I view this as an opportunity really to build a stronger system that provides supports for all the players in the systems, and specifically for the individuals who are facing potentially pretrial detention. I know there's a lot of work that's going to happen between now and March. I don't have a lot of questions, and I know I'll also have an opportunity through LPSC to be part of those discussions. One thing I wanted to just sort of elevate and sort of put on the table for you all, not even necessarily for a response now, but as I look through this, I'm wondering about whether we have started with what are the metrics and evidence that we have a successful pretrial program. Because I feel in some ways this is very much, the instigation for this immediate work was for like budgetary reasons. And we could end up with this process with here's the amount of money we have, what can we do with that based on, best practice. I think it would be useful to, and maybe this has already been done, but what are the indicators of a successful pretrial program? Is it, the number of outstanding bench warrants? I was surprised, like the 15,000 is a huge number. Is it the number of people who have been released on cash bail? Is it, is it a, low failure to appear rate? Is it, there's low rates of criminal activity while people are in pretrial release? Is there, are there a low number of individuals held in pretrial custody? Has there been criminal activity or engagement with the victim during pretrial release? What are the measurable impacts on those who have been held on pretrial detention? Those are real impacts. And so if we look at what is the goal of pretrial release, and how do we measure that, both for the individual that potentially may be held or released, but also for the larger community as well? Because what I've found in my public service is generally here's what we're trying to accomplish, and here's what we would define as success, using a number of different measures and disaggregated measures at that, is then it leads to actually and how do we fund that? Because what I hear from both sides is an interest in having people being successful during that pretrial period. And so I think when there's a agreement on we want people to be successful, here's how we might measure that, both for the individuals, but also for the community at large, that we can find the resources or allocate the resources most effectively to meet that measurement. So I would be curious if anybody has thoughts on that, or how the current system measures up to some of those metrics. Because if I was also think of a from to scenario, we're going from something to something else, and I would hate to go from the current system isn't working well against metrics which we think are important, and we're moving to a system that is not going to improve that, but we're just doing it for budgetary reasons. So I just throw that general sort of question out there, or just thought about as we move to a new system, how we approach it.
Yeah, I appreciate that question, Commissioner. And I will say just at the core of what defines pretrial success, just across the board, is really successful court appearances and individuals not experiencing a new arrest while on pretrial release, right? That is our base goal of pretrial. When we talk about all of the other metrics, I think that they're incredibly important, and we'll be having conversations about what those metrics and performance indicators look like as we start to build out a program, and those will be sort of locally for us to measure how our system is working well. I don't have that data available right in front of me, but we are really working on that snapshot to see where we are. We're challenged by our current data collection systems, and so I just want to be really honest about that. That we might not have all of the data for the before, but we will certainly be setting it up for the after. And I am grateful that we have now research and data capacity within LPSIC to really help determine what those indicators will be. So I appreciate that. I know each of our agencies, maybe Save for the Defense, have access to research analysts that can also help shape these programs and have been participating in some small data analyses as we've been working on these options. So thank you for that.
Does anybody else want to offer a thought on like our current system or the metrics we're using and how that's going to guide us to a better system? On the
You know, I really agree with, this is Judge Greenlick, I really agree with Sarah at the core. I really am hopeful that some sort of transition center that can help connect people to resources will drive down the failure to appear rate and the reoffender who is committing minor offenses over and over again. And I just think that should be a population that the county really focuses on, and that is where we're seeing the highest levels of failure to appears in the minor offenses, the quality of life offenses. So I agree that that's an important thing to look at.
I mean, I think the most important thing is to reduce the need to even have a pretrial system by reducing the amount of time from initial arraignment to a conclusion in the criminal process. Warrants get in the way of that, right? So when people don't show up for court, that lengthens the process. It causes congestion for the courts. So finding a way to get people to court so they can address these cases while they are pending in short order, I think is a huge part of what all of us want to see happen.
Stacey, you have anything? You don't have to.
I would echo those comments. Thank you.
Great. Well, I'm also going to share appreciation that we had an opportunity, I know Commissioner Moyer and I did, to go down to Pima County with all of you and a number of other partners where we saw a robust system of services that is present in Pima County, and again, I including a transition center. And you know, I think about Sarah, it will be great to see the data we have currently, and then again, I think it always can be, if we know where we're trying to get to, we can make those like targeted investments, whether it's a transition center or something as basic as getting people a cell phone. If that's like the key to getting people, to remind them to, like, you have a court appearance tomorrow or something that you need to do, that seems like a much lower dollar way of supporting somebody being successful. And if that's what the data shows, that will help more people be successful. I would hope those are the types of things that will come before the commission and come to us so that we can, I think, reach our our common goal here, and also have it be something that we can point to the data that shows actually it is achieving what we want out of our pretrial system. So again, I just want to really thank everybody for doing the hard work, and looking forward to your coming back with recommendations in March.
Thank you. Commissioner Jones-Dickson.
Yeah, great. Thank you, Chair, and thank you both for bringing forward the budget note, and thank you for being here this morning. We have to start somewhere, and this is a really good start. I appreciate all the information that you've provided so far. Sarah, a couple notes I just want to flag. I'll be brief. Judge Greenlick, you brought up, we need options, which is true, and then the whole transition center, these are ideas that we've been talking about as board and through my office, so it shows that we're going in the right direction. The other thing that I wanted to just mention, I really appreciate the fact that you put in there as far as the technology and what we're looking at. Yesterday I met with, or 2 days ago, I met with our Spark team, and they talked about just the future. Is there an opportunity, or have we engaged with them around this work? I'm thinking about just the alignment across all of the, we've read all the services, right? So it would be good as far as we're considering budgets and things like that. Have we done that? Is that within the roadmap? Are we planning on engaging with them?
We haven't done that yet, but I think we are planning on engaging with them once we have a sense of what the options are to make sure that we're in alignment.
Got it.
That's a good flag that we could do sooner.
Got it. And then also just thank you for sharing and being clear as far as the reality. We have to invest. We need funding for just the services. That's clear. You know, that's a budget ask. And then lastly, I'm extremely hopeful. Over the last week, I've been able to engage with folks that are going through the pretrial. And just hearing their experiences in general and just the opportunities and for the future. And they're hopeful because they had a direct connection with policymakers and they provided recommendations. So I would encourage us to continue to do that. I know we have the Justice Fellow that's here as far as directly getting feedback from them. And then also just expanding the table. I know we are very insular as far as like we can handle it as a community if we know what the issue that we're trying to address. So let's expand it, I would say, as far as coming up with the options and the solutions for our community members. One person in particular that I've been able to meet over the last 3 months that's going through the pretrial process, just hearing about the overall transformation for them because of the sense of community and the services that they received, it's been it's mind-blowing. So huge opportunity. And then lastly, I'll be remiss if I didn't say thank you, Deputy Chief Reardon and Steve Cicatelli, for your work over the last 2 years as far as bringing me up to speed as far as the work that you're doing and the coordination. I know you guys have been doing like one-offs and things like that, but it seems like we're being way more intentional and we have the right people in the room and we're all committed to it. And lastly, I just want to acknowledge, I appreciate your just vulnerability, Attorney Lowe, as far as like just the space that you're in and just being sensitive to and just knowing the overall impacts and that our work is extremely important. And same with you, Stacy, and everyone else. So with that, onward.
Thank you so much, Commissioner. I just want to thank everyone for their work. I have some questions, and some are for the DA's office, the defense, the courts. So I'm going to follow up in writing with those and to share those out. And really they're all like about digging deeper in and understanding the different pushes and pulls that each part of the system have as we're thinking about this issue, which I know is basically the crux of all the work that's happening. I want to thank Commissioner Brehm-Edwards and Moyer for the budget note, and also appreciate the work that Lipsick has been doing for the last year plus on this work on pretrial. And everybody's commitment to trying to figure out a solution. I mean, I think that the realities of the budgets for all of our entities are real, and we have to figure out how we can be the most effective in putting together a system that really reaches those goals that you talked about and recognizes kind of those perspectives. And it's really hard work. It's really difficult. I had the opportunity yesterday, and Commissioner Singleton is still there, to go up in Seattle and sit in and learn about the LEAD program that they have up there, and it was really fascinating. And I think that there are definitely things that we can take away from that and see how we can bring some of these back, because it really is about like how are we using our systems to have the best impact for people. And we talked about like the so many of the folks who are coming because of these like misdemeanor charges who are repeating again and again, and like is our system effectively really like doing what it needs to help those people on the path that they're on, while recognizing the fact that there needs to be accountability to their actions. And so I'm looking forward to delving deeper into that conversation and takeaways, because I think that has, as we're talking about diversion programs, deflection programs, and kind of like where we are right now with the failure to appear issue and the impact that has on the system, I think there's work that we can be doing together on that. So I'm looking forward to the continued work that you will all do, and just appreciate the way that everybody everybody is really, trying to make a system work that we know is imperfect, that is under-resourced, and yet we're trying to do the best for our community and those people that are most impacted by this. So thanks very much. We look forward. Yes, we are. Building a system of care in America's favorite county, yes. So thank you so much, and we'll look forward to more in March.
Okay, R2, budget mod.
Thank you.
R2, budget modification DCJ 00526 FY 2026 treatment courts budget rebalance.
May I have a motion? Commissioner Jones-Dixon moves, Commissioner Brim Edwards seconds, approval of R2. So we go into now a couple of different budget modifications from DCJ. And some of our other justice system partners based on, again, state rebalance impacts. So just appreciate everybody being here today. We've got the first one up is around the treatment court program within DCJ and the Multnomah County District Attorney's Office. So I want to thank the staff from all of those entities for their work in the specialty courts that happens, as well as trying to navigate the different budget impacts for the state dollars that have been advocated. So with that, I will turn it over. I think, Tiara, is that to you? Good morning.
Good morning, Chair and Commissioners. I am Tiara Hubbard. I use she, her pronouns, and I am with the Department of Community Justice, the Adult Services Division Director. With me for this budget modification presentation is Caroline Wong from MCDA and Colby Dixon from DCJ. Today we'll be reviewing the Specialty Treatment Court budget modification related to the final CJC award for the 25-27 biennium. This funding supports both DCJ and MCDA, so each department will speak to the specifics of the bud mod for their respective area. Next slide, please. This slide helps give context for the funding for this bud mod, within this bud mod. Multnomah County receives the funding for specialty courts from the Criminal Justice Commission, also known as CJC. The county participates in these courts along with OJD, community-based organizations, the District Attorney's Office, and defense firms. The 5 specialty treatment courts in Multnomah County include the Dewey Intensive Supervision Program, known as DISP Court, our Mental Health Court, Success Through Accountability, Restitution, and Treatment, known as START Court, and Strategic Treatment and Engagement Program, known as STEP Court, and newly the Veterans Treatment Court, which was established for the 25-27 biennium. Next slide, please. While most of the state rebalance occurred in October, the final funding decisions took longer for these awards due to several factors. When initial funding levels were announced, the level of funding was greatly reduced, specifically in our DISP court, as well our other courts were impacted as well. Multnomah County protested those awards and was not successful in obtaining any additional funding, specifically for our DISP court. Discussion occurred with the partners and service levels, and expectations were established due to the reduced award amounts. With that being said, this presentation focuses on the budget modification needed to true up the budget with the final revenue that was awarded. Next slide, please. This chart shows the total changes for both departments in the fiscal year 2026 budget. While the award is for 2 years, this budget modification only focuses on the first year in the biennium. Next slide, please. This chart depicts the impacts to each department based on the changes in total CJC funding for fiscal year 26. Additionally, MCDA has carry forward revenue from fiscal year 25 related to the 23-25 award that ended in 12/31 of 25. Next slide, please. This, as the title indicates, is specific to DCJ. The impact for each court is listed, but to quickly summarize, both DISP Court and START Court saw a reduction in provider pass-through funding, mostly related to court coordination from our community-based provider. Mental health court saw a $688 increase for the pass-through funding related to our community-based provider. And finally, all funding in DCJ for Veterans Court, the Veterans Treatment Court, is new due to the startup of this court in biennium 25-27. When DCJ put together our budget last January, we did not estimate anything at that time. We didn't know the awards. I will pass this over to Caroline to discuss the DA's budget modification. And next slide, please.
Pardon me. I'm Caroline Wong. I'm a senior deputy supervising our newly formed Treatment, Accountability, and Specialty Court Units, otherwise known as TASC. TASC was formed in January of 2025 to enhance resource efficiency and to ensure consistent staffing for long-term success in treatment courts. Historically, these diversion programs in specialty courts have widespread support as they focus on treatment in lieu of jail or prison. For our line item adjustment, service delivery at MCDA is not materially impacted. For Start Court, which is our prison diversion on property and drug crime cases, the current grant award funds .29 attorney FTE, and the previous biennium carry forward increases that FTE to .39 FTE for fiscal year 26 and funds additional temporary personnel costs. For Step Court, which is our prison diversion on certain ballot measure 11 violent crime cases, the grant award funds .32 attorney FTE, and with the previous biennium carry forward, it increases that FTE to .6 for fiscal year 26. Additionally, we did receive new grant award funds to fund .15 FTE of an attorney handling veterans treatment court cases. As we are in our implementation phase, that amount is low for that reason. Next slide, please. Any questions?
Okay, are there any questions from the board on this budget modification? Commissioner Moyer.
How does the allocation from the CJC differ from previous years of this grant cycle? How, like the .39 compared to last year, and also what is the actual staffing versus what we are funded at?
Overall funding from CJC was reduced when you factor in current service level. Additionally, our courts, each of our courts were funded somewhere between DISP being the lowest was only funded at 47% of our funding ask. I think our highest was at 85%. So we did not receive the funding that we requested to support the courts, any one of the courts. Veterans Treatment Court being a new court, so we had asked for what we thought it would cost to run that court. I can only speak to DCJ for the staffing. Colby might know the numbers, or Caroline. DCJ receives 3 POs that work within Start Court. Step, we don't even receive 1 full PO for that court. Mental health, we don't have any PO staffing from that. We provide the pass-through contract funds to support our providers. And then Veterans Treatment Court, we don't receive any staffing.
Thank you. And for the DA's office, we receive part-time funding for our part-time Start Court and Step Court DDAs, part-time funding for the Veterans Treatment Court DDA. We did not have any CJC funding for our DISP court, or intensive supervision for DUI offenders. However, our office did apply and received a ODOT grant award, and we filled the position in November, so our office is going to have to come back for a budget modification for that. That is a full-time position for that DDA to do that work, but we are not fully funded for all of the positions in our office as well.
Thank you. Any other questions? Commissioner Berman Edwards.
So this is just sort of on that same line. I'm curious, so we protested. Did other counties do that and get funding, or was it just an across the board? We're sticking with what we.
There were There were 5 courts that protested. I don't know the outcomes of any of the protests outside of our own, but we were not, our protest was not funded.
Okay, it'd just be interesting if, to see whether other counties, if they receive funding. It's very disappointing that the low level of funding. A question about the Veterans Court. So that's a new court. Do other counties have that, or is it a uniquely Multnomah County?
There is a Veterans Treatment Court in Washington County as well as Marion County. It is new to our county. When we looked at our population, we did note that there are many veterans who reside in Multnomah County. It is a population that needed to be served. It is a population that we saw many criminal cases coming through the justice system on a regular basis. And so there was a real need to pull together a program specific to their needs.
And this is just a side question about the Veterans Court, but other than the designation of veteran, is there other criteria about how you land in that court versus somewhere else?
Yes, absolutely. Great question. So they do need to be able to access veteran services. So they cannot have been dishonorably discharged, for example. Most of the charges that veterans face are eligible for treatment court participation, with the exception of some sex crimes, homicide crimes, and crimes against children. Otherwise, most of our specialty courts normally don't allow domestic violence offenses, for example. But when we looked at the data and the types of cases coming in involving veteran defendants, we did note a pretty high rate of domestic violence charges coming through. And so we wanted to develop a program that supported them in that area and to work with veteran services to provide better intervention, counseling, and programming for them.
Great, thanks. Just as a follow-up, I don't need it now, but I would be interested in sort of each of the courts and how, what the data shows of when we have these adequately funded, what kind of outcomes we get, how many individuals are served through the specialty courts. So just as a follow-up, that'd be something I would be interested in. But thanks for the presentation today.
Thank you, and you were okay. Yeah. Thanks so much. I appreciate the work that went into trying to figure out how to make things work with more limited funds. I will say, and this is something that I know has come up in conversation before, but we know that the allocations we get from the state are not enough to fund these. And I know that we just recently expanded to the veterans, a new veterans course. So I think to build on Commissioner Brehm-Edwards, like just making sure that we are getting kind of the outcomes and effectiveness of the investment so that we can not be trying to spend the limited dollars like so thin that we're not getting those outcomes for folks who are engaging with the system, I think is going to be a really important thing as we move forward with this. All right, thank you so much. Marina, can we have, was there any, I'm sorry, was there any public testimony on this item?
No, Chair, I did not receive any.
Okay, thank you. Can we have a roll call vote?
Commissioner Moyer?
Aye.
Commissioner Brehm-Edwards?
Aye.
Commissioner Jones-Dixon?
Yes.
Chair Vega Peterson?
Aye, the budget modification is approved.
R3, budget modification, LIPSIC 00226, MCJRP, CJC budget rebalance.
May I have a motion?
So moved.
Commissioner Brehm-Edwards moves, Commissioner Moore seconds approval of R3, and welcome back, Sarah Mullen. I will turn this over to you.
Thank you. My chair is still warm. Good morning, Chair and Commissioners again. My name is Sarah Mullen for the record, and I am the Executive Director of the Multnomah County Local Public Safety Coordinating Council. I am joined today by Senior Deputy District Attorney Caroline Wong, Adult Services Director Tira Hubbard, and Business Services, I can't remember your title, John Harms-Millant from the Sheriff's Office. Today we are going to be reviewing the Multnomah County Justice Reinvestment budget modification related to the final CJC award for the 2025-2027 biennium. This budget modification includes all of the county partners who receive revenue from this funding and the adjustments based on the final award amount. Next slide. All right, so this is an overview of the Justice Reinvestment Program, often called House Bill 3194. The Justice Reinvestment Program works to decrease prison use, hold individuals accountable, and focus on community safety by reducing recidivism through efforts by various partners in the public safety system. Within the CJC Multnomah County Justice Reinvestment Program, there are 4 streams of funding, which include the formula, the evaluation, a competitive, and the victim services funding. Today's budget modification focuses on FY 2026, which is the first year of the 2025-2027 biennium award from CJC. This presentation will also include the DA's 23-25 carry forward balance. Next slide, please. All right. This slide shows the FY26 adopted budget for each county partner, and the revised column shows what the FY26 budget will be if this budget modification is approved. The first 4 lines are in reference to the CJC revenue changes for the 25-27 award, and the 6th row adds the DA's carry forward for 23-25, netting the total changes to the CJC funding countywide. Next slide. All right. Within this budget modification request, LIPSIC will see a total increase in $29,086 for the victim services funding. This will be allocated to our current providers who are supporting this work in the community. I am going to now pass it over to DCJ to explain their budget adjustments. Next slide, please. And Tira, you are up.
Again, Tira Hubbard, I use she, her pronouns, with DCJ, Adult Services Division Director. So within this request budget modification, DCJ has removed our funding for pass-through and program support related to operations for the treatment dorm. We've also reduced wraparound supports based on estimated qualified clients. Additionally, the JRP award did not fully cover our salaries for our FTE that was supported in this grant due to the timing of the contract negotiations and the application due date. We utilized County General Fund to support this shortfall in fiscal year 26 from a supplies budget. DCJ did see a small increase in our housing pass-through to a community provider. Next slide, please. And at this point, I'll pass it to Caroline for MCDA.
Good morning again. Caroline Wong with the Multnomah County DA's office, Senior DA supervising our task unit. Task also houses attorneys that are assigned to our Justice Reinvestment Initiative. McDermott maintains its high level of service and prison diversion opportunity with an average of about 85 eligible presumptive prison cases that we flag and file from our office each month. And we maintained a prison diversion rate of about 70% in 2025 through Q3. MCDA's budget modification maintains the 1.0 data analyst FTE and funds additional temporary overtime and indirect expenses. The treatment court program offers increased FTE by 0.25 FTE and funds additional temporary and indirect expenses. We do have carryover funding listed on the slide, which will help support rising personnel costs. Next slide, please. And I'll turn that over to MCSO.
Thanks, Caroline. Good morning, Chair, Commissioners. John Harms-Millant, Chief of Business Services, Sheriff's Office. Our budget modification regards the staffing of the treatment dorm at the Inverness Jail. This moves $237,000 to the Sheriff's Office budget to pay for 2 corrections counselor FTE that will staff that treatment dorm. Thank you.
All right, next slide. That concludes our presentation. Any questions?
Thank you. We'll see if there are any questions. The questions, Commissioner Jones-Dickson?
I don't have any.
Okay. Commissioner? Okay.
So I had one question that was, it's related to the materials that the APR that was submitted, and it's the portion of it that talks about the operational transition of the treatment readiness dorm from a community-based provider to MCSO, and talks about, because making this movement will reduce the total cost to be able to meet the revenue reduction. And I was looking at the materials and I was trying to see if there was sort of a assessment of the impact of on the individuals who are in the treatment readiness dorm, and I'm wondering if we have assessed that and whether there is an impact with the shift?
I'm not personally qualified to speak to that. I do have a good friend named Steve in the audience who might be able to
I see him right behind you.
I actually have two good friends named Steve. Where's the other one? Oh, Steve, here. Why don't you take my seat?
I would hate to have had you come to the meeting this morning and not have an opportunity.
Appreciate it. Thank you, Chair and Commissioners. Good morning. My name is Steve Cicatelli. I'm the Programs Unit Manager at the Multnomah County Sheriff's Office. One of the cool things that we all worked on together through this transition was lessening the impact on the adults in custody on the treatment dorm. So I will credit our HR department, and we worked in lightning speed to onboard temp and then permanent individuals. There was maybe a week where we were kind of down in staff and we had to subsidize with existing staff. But we actually, the VOA counselors who were working on the dorm were so invested that they came on board. And so we continued service with actually the same staff that was delivering before. There's a slight reduction in staff, but we've transitioned, and I feel like we've met the kind of standard benchmarks that we were providing before the transition from the group participation and the engagement. We're working on formalizing how our staff will be doing the evaluations and ASAMs, making sure we have the right documentation and templates. And then going from there, we're going to be working with DCJ to kind of align our services to actually enhance and grow what we're doing on the dorm.
Great, thank you. I really appreciate that work happening, even though it's related to a budget reduction, that the impact on those we're serving is reduced.
Thank you. Any questions? Commissioner Moyer.
Yeah, just to clarify, this is a pre-treatment dorm, not a treatment dorm, correct?
That is correct.
And I know that this is difficult since this is a reduction and not a addition, but what level of resources do we have or not to make sure that as people transition out of our pre-treatment dorm, they are transitioning to treatment in the community? Is that an area that we have the funding to facilitate, that we are, is that threatened? Does it still have challenges in an area that we should try to look at enhancing? I'm just wondering, one, does this impact that? And two, how is that going? And I'm sure that also impacts the success of this program.
You know, we've held pretty strong with our ability to do treatment coordination. Again, it's a collaborative effort. So my team is having a lot of communication with DCJ POs to figure out who is holding the baton as we go into the transition. Some of this, specifically relative to McJerp, I would argue, relates to what is happening in the court and what they're writing as expectations when someone is sentenced. So that's a little bit outside of our control, but existing McJerp individuals are getting treatment referral, placement, coordination. Sometimes the PO is doing it, sometimes we're doing it, depending on the situation and the need and the conditions. And then there's coordination of, okay, if you're going into a residential setting post-release, who's doing the pickup, who's doing the transport. I would always love more to do more intentional coordination, but overall, I think that is an area, and that spans even beyond just the McJerp population. We're working very closely, Start Court, Step Court, all of those treatment courts have a big lift from both of our agencies.
I can add to that for DCJ, part of the shift allowed us to move our personnel less focus on completing pre-adjudication assessments. We're still providing pre-adjudication information, but we shifted our personnel to really focus on working with the individuals. All individuals in the McJerp program are on what would be a downward departure or presumptive prison. They are destined for prison, if not for this program. And so we really believe in focusing as much of our resources and our supervision and doing enhanced supervision, working with them more closely, connecting with the jail as much as possible to try and create those warm handoffs. Many would benefit from residential treatment. There's not always residential treatment available. As much as we can to not have people held in custody while waiting for a residential treatment bed, if we can get them into an outpatient or a medicated assisted treatment or a behavioral health support or peer support. So as much as we can, we try to use our POs and sort of leverage those relationships. Once they're out of custody, OHP can pick up the bill for those treatment services. So that's of benefit to the county anytime we can get them released into the community and then get them back on their OHP and get them connected into treatment services.
Commissioner Jones-Dixon, did you have a comment? Okay. Thank you again for this work. It's always hard when you're trying to figure out how to deal with these budget reductions that are coming in when you have a system that there's such great need. And so I just appreciate the collaboration and partnership in bringing this forward today. Marina, did we have any public testimony on this?
Yes, Lightning.
Okay, and you're all welcome to take a step back so we can have our public testimony. Thank you.
Yes, my name is Lightning. I represent Lightning Super, We the People X. One of the things, I do approve of the budget modification. One of the concerns I had was on that local public safety coordinating council and also on the pretrial subcommittee and the pretrial arraignments. One of the things I wanted to make it perfectly clear is one of the reasons why I worked alongside Federal Judge Michael Simon on also working on the policy itself, the body-worn camera policy for the Portland Police, was to have that data, to have that. If law enforcement does a written report, they're pretty set on that report. And when you go up in front of these pretrial subcommittees and different things like that, they're going to look at that written report from law enforcement and say, hey, we're not going to do a pretrial release or arraignment. You're not going anywhere. But when we have the body-worn camera, video and audio, that changes the whole game. It changes everything for that individual. And we have so many people in our communities that are traumatized by sitting in the cages. And in my opinion, and I'll say this not to all law enforcement, that there is law enforcement out there that enjoys traumatizing our community members. They're sick. And we need to weed those sick ones out. And the way we do that is through the body-worn camera, video and audio analysis. And that can dismiss these cases immediately when presented to a judge. But when you have a written report from law enforcement, and they may be a blatant, outright liar, that community member doesn't stand a chance. That is why it's so important, and I'll point at Chair Peterson. Your legacy will be universal preschool for all. That is your legacy, and I commend you on that. But your other legacy can also be to make sure that funding is in place to put those cameras on these sheriffs, corrections officers. You have that ability through the supportive housing services measure. You can set aside funding. And when they're talking about all these people coming in and out of these jails consistently and mental illness and this and that, they're predominantly talking about the whole homeless community. Those are the people that suffer the most. Those are the people that are traumatized the most. And if you can get that funding in place, sustainable, long-term funding for this body-worn camera project, you will change their lives forever. And cases will be dismissed, and they won't be traumatized in these cages. Traumatized over and over and over again.
Thank you. Thank you. All right. No other questions from the board. Marina, can we have a roll call vote?
Commissioner Moyer?
Aye.
Commissioner Brim Edwards. Commissioner Jones-Dixon.
Yes.
Chair Vega Peterson.
Aye, the budget modification is approved.
R4, to adopt and extend the declaration of emergency in Executive Rule 432 until April 11, 2026, due to the impacts of federal immigration enforcement actions.
May I have a motion?
So moved.
Second.
Commissioner Jones-Dixon moves, Commissioner Moyer seconds approval of R4. So I want to begin today by sharing that over the holidays, my office received a string of emails and calls from neighbors in the Brentwood-Darlington neighborhood who were asking for help to find two neighbors, Mario Cruz and Magdaleno, who were kidnapped by ICE the day after Christmas. Both Mario and Magdalena were the primary breadwinners for their families, and their children attend the local elementary school. As a parent, my heart breaks for their families and the whole community that's been affected by these cruel actions. Add to this the horrific murder of Renee Nicole Good in Minneapolis and the dozens of lives that have been lost in ICE detention this year, and we can only conclude that ICE activity is a threat to our entire community, and it is a threat that's growing every day. In light of this, our community is calling on us to act, to deploy resources to support the families impacted by ICE activity, like those of Mario Cruz and Magdaleno, and to do all that's in our power to ensure the safety of neighbors going forward. My hope is that the action we have before us today can keep the county's attention focused on responding to the crisis in front of us. Last month, on December 12th, I declared an emergency in response to ongoing impacts from federal immigration enforcement, providing increased flexibility and direction as the county continues to respond to harmful U.S. immigration and customs enforcement activity. Legally, after 30 days from the chair's declaration of an emergency, the board needs to vote to extend the emergency declaration. As noted in the APR and resolution, the action I'm requesting of my colleagues today is to join me in extending the emergency declaration for 90 days until April 11th. This will allow the continuation of operational flexibility to allow county employees to better perform or facilitate emergency services and provide the ability to suspend purchasing rules to accelerate getting resources into the community. Additionally, the 90-day extension will allow for the actions directed in the board adopted resolution on December 18th, 2025 to occur and come back to this board for consideration as an ordinance in the late February, early March timeframe. With that, I will open it up to the board for any questions or comments. Commissioner Bernard, yes, go ahead. There's only three of us, three commissioners. So.
I'm just going to say, want to start with thanking the chair for the original emergency declaration. I'm very supportive of the commission extending it, and I think it's really important that we continue to communicate to our community that not only is this top of mind, but we want to take every step we possibly can in action to protect our community members, and at the same time, also recognize that there are communities across the country that are having similar impacts, and just say that I'm sure we all stand with Minnesota, as well with sort of the impacts that they're facing with the several thousand federal agents descending on their community to sort of wreak havoc and terrorize their community. So I'm going to be a strong yes, and again, thank the chair for the original declaration.
I echo those comments. I wore this shirt for a reason today, which is my No Kings shirt. And I'm sure, like every other locally elected official in a city that has been unfairly targeted, wish that we had more power within our discretion to do things. So I am glad we are actively figuring out every lever that is within our disposal. I will say this, knowing that it is not legally binding, but may it reflect my view. I strongly wish if we could legally bar ICE from being in Multnomah County. This has gone so far beyond any legitimate law enforcement activity that it is actively become a public safety threat to all in our community. It is an unacceptable abuse of federal power that is totally disassociated from the Constitution and has absolutely no respect for the rule of law or due process. And I am proud of this body for remaining vocally in opposition and to try, to the extent that we are capable of, to show that that is not who Multnomah County is. That we are not participating, and even more importantly, we are resisting what is, to me, un-American, to be treating our neighbors, our residents, our classmates in a way that is inhumane and immoral and totally contrary to the values of this community. So I appreciate the actions the chair took, and I happily lend my support to extending this declaration.
Thank you, Commissioner. Commissioner Jones-Dixon.
County Attorney, is that possible? What Commissioner Moyer just put on the table?
Thank you for the question, Commissioner. I think that the Commissioner of District 1 first started off with stating pride for Multnomah County is doing all that it can do, and I have been in close collaboration with your offices to assure that we're able to do that, and I think we are doing that right now.
I'll follow up. No additional comments. I appreciate you bringing this forward again, Chair, and extending it, us being proactive. It means a lot as far as just communicating with the county and our community members that call Multnomah County home, what we're doing, and how we are staunchly against what's coming from our federal administration. So we will continue. Thank you.
Thank you. And I do believe we have public testimony on this item. Is that correct, Marina? Thank you.
Yes, Lightning.
Yes, my name is Lightning. I represent Lightning. No justice, no peace. One of the things that I have my biggest concern on President Trump and his over-aggressive attempt to remove a tremendous amount of people out of the United States is that you really need to start to reflect, as Pope Leo has stated. And one of the things you need to think about is that when you have people in the communities that have been here 5, 10, 15, 20 years, they are the fabric of these communities, the fabric of the neighborhoods, the cities, the counties, the states. They are the fabric of the United States. And when you start to try to remove these people, something you covet the most is the Nobel Prize and elections. You will severely damage your opportunities to win. I think Stephen Miller is making a lot of the decisions for you on this matter. And I think he's making some tremendous mistakes for your legacy, President Trump. Your legacy could be, you could be considered a humanitarian if you adjust your course, if you go down a different pathway. You do nothing but win at the end of the day. If you continue to go in the direction you are, you will lose your legacy, your Nobel Prize, elections. You will lose everything. There is no reason for you not to reflect, to adjust, and to look at the people and understand they've been here for years. They are the communities They are our neighbors. We stand along them. We will fight with them in every legal way we can to stop you from making them suffer and removing them from their families. You must rethink and you must change your direction that you're going, or you will lose elections, your Nobel Prize, and that means everything to you. Set up a meeting with Pope Leo and have a discussion with him and then make a change. You need to make a change of your behavior on what you're doing. And nobody's been able to do that as of this time. Change your behavior.
Thank you. So I appreciate the board's comments and support today for this. I did want to share that even though Commissioner Singleton wasn't able to be here today, she is also strongly in support of this action. It is a real sad reality that the federal attack on our community continues. In moments like this, it's more important than ever to find moments of solace. And for me, I've been so encouraged with the solidarity I've seen across our local governments, organizations, businesses, and individuals. I think it's something that we in Portland and Multnomah County should be very proud of. For example, recently, after the board passage of the resolution and funding allocation in December, City of Hillsborough staff reached out to Garrett and Salome to express their appreciation and share their own plans for actions that they're taking. And as for the county, I've been really impressed and proud of our ability to mobilize and coordinate across departments through our emergency operations team. I also want to thank our ERGs, especially our immigrant and refugee ERG, who have been supporters of this, but have also been providing feedback on the actions that the board is taking and the steps that the county is taking. Through this effort and the work of this board, we are reaching community organizations that might not have interacted with the county before, and our relationship with other jurisdictions continues to strengthen in response to all that is happening. I am proud that Multnomah County and the other governments in our region are modeling what a responsive and compassionate government looks like. Given that H.R. 1 provides $45 billion to ICE through fiscal year 29 just to expand detention capacity, our relationships and our partnerships will continue to be needed now and into the future. So, Marina, with that, can we have a roll call vote?
Commissioner Moyer?
Yes.
Commissioner Brim Edwards?
Yes.
Commissioner Jones-Dixon?
Yes.
Chair Vega Peterson?
Yes, the resolution is adopted. All right, thank you so much for all the good work today. Now we have time for board comment on non-agenda items. I'll open it up to commissioners to see who has any items that they wanted to discuss. Yeah, sure. Commissioner Jones-Dixon.
Yeah, thank you, Chair. I just wanted to call out just two things this last week. On Tuesday, the city of Gresham they swore in their new fire chief, Jeff Harrison. He was the first African-American firefighter to be hired about 19 years ago or 18 years ago there for the city of Gresham, so that was a big deal. We can clap for that. Yes. And then also, the following day, I met with the president of the fire union and a couple of the firefighters, and I sat with them over lunch, and they mentioned how much better as far as the response times have been out there in East Multnomah County. So they expressed their appreciation and looking forward to engaging in the ASP work, the ambulance service plan work, in the near future. And then also just want to give a shout out and a warm welcome to Dr. Nuri. He's a new staffer with Lipstick, and he's helping us. He's the, I forgot his official title. Data, yeah. But his PhD, he's crushing it right now on the youth violence prevention work in data matrix. So we're extremely encouraged and excited. And then same with Ennis, who just started a week ago or 2 weeks ago. He's our new continuous improvement manager through the Spark program. So those two updates this week have me on fire. And lastly, I think and this weekend we have the ribbon cutting in your district, Commissioner Moyer, at the library. So we're excited about that. And I think Annie mentioned we're launching the Everybody Reads program, I think this month. And we're looking forward to that program come March. So, yeah.
Any update, Commissioner Brim Edwards?
Yeah, just to build on the Everybody Reads program, I noticed the book this year is a little bit longer than last year. So I'm appreciated that we have some lead time to get reading. I know last year the program was super successful, and I especially appreciated last year, and I'm hoping this year as well, that we engaged with young people across our community with the authors. I know last year with Solito, the students who had an opportunity to engage with an author, it was, I think, a very inspiring and impressionable opportunity for them to have to engage with our Everybody Reads author. So thanks for bringing that up. I have just one thing that I wanted to do today. So in partnership with Commissioner Singleton, we have scheduled commissioner work sessions on deflection over the last several months and at the end of last year. And we, as a commission, discussed sort of the results we've had and the services that we really want to make sure that individuals who are engaged in deflection receive, and possible evolutions of the program as in the coming year. And I really appreciate the staff at the Pathway Center sort of sharing their expertise about their observation from the first years and what was working, what could actually then sort of move things forward in evolution. I wanted to insert today into the public record just a draft resolution related to deflection that I think reflects many of the commissioners' sort of recommended proposals or actions to involve the program. And I'm doing that not as this is the final resolution, but an opportunity for it just to be publicly out there, for others to be able to, commissioners to be able to co-sponsor it, just in light of we have to have it out in the public versus not in a private setting. I also want to acknowledge that both, I think it's reflective of many of the concepts that Commissioner Moyer and Commissioner Singleton have publicly shared to date. So I'll just give that to the board clerk and ask that it be posted, again, just to sort of continue to move the conversation and the discussion forward. And I also think it's important for the commission to continue to sort of press forward with that work, given that the district attorney has indicated that at the start of the year, he was changing how he was going to be approaching the charging decisions, and that naturally, given the integration between what the Portland Police Bureau is doing and the DA and his charging decisions, we should be taking action to ensure that we are providing the necessary supports for individuals who may be who are in a new environment. And that's all I have.
Thank you so much. Commissioner Moyer.
Yes, I have a few things. One is incredibly exciting. The Northwest Library is having its ribbon cutting on Saturday and will soon be open to the broader public. I am extremely excited, having seen it in various stages of construction. This is going to be such a great asset to Northwest Portland, and it's always so fun to see a new library come on board. I also, since this is our first meeting since the close of 2025, which has been quite a year, I wanted to thank the employees of Multnomah County for really exceptional work in an incredibly difficult environment. I think when people ask us how have federal policy changes impacted the county, I feel like we are where it hits the ground, that we actually see the people that we can no longer provide a service to, or we have a name associated with somebody that we saw fall through a crack. And I think that probably takes a toll on our workforce. And, you know, even if your job does not require you to be in the field day to day, we are of one mission, and everybody is here to deliver for our community, and therefore I think feels when we have to make cuts or close programs or not be able to meet a need we did not anticipate, like the non-payment of SNAP benefits. I think every employee who has persevered through this has used every ounce of creativity to try to support people when those supports have been limited or eliminated. I am heartbroken about the employees that are no longer with us due to budget cuts that nobody wanted to do. And I empathize for what it feels like to go into another year where budgets are going to require awful choices. So for what it's worth, you are seen and you are really valued, and I am honored to work with you every day, and I thank you for everything you have done through an incredibly difficult year, and I stand in solidarity with doing all we can every day, showing up when we cannot control the world around us and trying to do our best. So thank you.
Thank you so much, Commissioner Moyer. I really appreciate your words there. Thank you so much for grounding us in that. Commissioner Jones-Dickson, did you have an additional thing you wanted? Okay. Thank you. I just wanted to touch base on just a couple things. I'm also looking forward to the grand opening of the grand opening of the Northwest Library this weekend on Saturday morning. I did want to just acknowledge and celebrate the fact that Marina is back full-time with us. Yay! Yes, and so she's back. She's already digging in such great ways. So as we're moving forward here, please reach out to her. As we're looking at our board requests and time on the agenda. She has the most up-to-date information. We also, we're going to be sharing more information about this, more details about this, but we're doing an update to our Granicus system on the board documents and the workflows on that. And so that's going to be happening in the next month. I made it clear, like, I want to make sure that this board has opportunity to learn about the system, what it's going to look like, have a one-pager. So all of that will be coming as it's being brought forward. But I think all of us will be very pleased with the improvements both in our workflows, and I know Marina hopefully will be very excited about the improvements for her workflows, but also the ability to make a lot of the documents and work publicly accessible, including like who's providing testimony and some of the materials and all of that. So I think lots of good things to be coming on there. And then I just wanted to, I talked a little bit about the trip to Seattle that I took to look at their LEAD program, law enforcement assisted diversion. I think there's a lot of good learnings on that. So we're going to be debriefing on that and sharing more about that as time goes on. So appreciate this. Looking forward to a really great year with this board. I'm calling this thanks to Commissioner Jones-Dickson, this is my fourth quarter, final quarter. So so I'm here for it, for the work, and really proud of all of the work that we're doing at Multnomah County and the work that we're doing as this board. So thanks, everyone. That concludes today's regular board meeting. There being no further business, we are adjourned.